Opposition Senators Gerald Ramdeen and Wayne Sturge have raised concerns about the government's planned amendments to the Miscellaneous Provisions Trial by Judge Alone Bill 2017, which could see the removal of trial by jury. In a press conference on Sunday, the UNC senators claimed that there should have been wider consultation on the matter. Peter Christopher reports.
With the Miscellaneous Provision Amendment debate set to begin in the Senate on Tuesday, the UNC senators raised their concerns at the opposition leader's office in Port of Spain. The senators argued that due to the magnitude of the bill, it should have gone through a consultative process.
This piece of legislation has very far-reaching consequences, as does the piece of legislation that is presently before the lower house. And we consider that both pieces of legislation ought to have been brought to the Parliament with the requirement of a special majority. With respect to the piece of legislation that will be debated on Tuesday, we consider that that piece of legislation should have had far-reaching consultation with the members of the citizens of this country.
Opposition Senator Wayne Sturge admitted that much of the framework in the bill resembled a draft pushed forward by the former administration, but he felt new clauses in the bill were problematic.
There are 2 or 3 very serious changes made in his 2017 bill. But if you take out those 2 or 3 serious far-reaching changes and you look at the bill he's brought, you would see it is identical to the bill piloted by the People's Partnership in 2014 with safeguards.
Senator Sturge pointed to Clause 22 of the bill, which says that should the Director of Public Prosecutions fail to place an indictment against an accused within 12 months, a legal application can be made to allow that person to be set free. However, Attorney General Faris Harawi said it was not that simple.
Section 22 of the bill before the Parliament to remove preliminary inquiries has a very important provision in it, which says that the DPP shall approach the court and ask for extensions of time in the circumstance described in Section 22. It is a completely different thing to say that the indictment not being filed within 12 months will cause an absolute discharge. That is ridiculous.
The Attorney General also countered the opposition's claim that the bill sought to completely remove trial by jury.
But I want to remind that this particular bill before the Parliament does not seek to completely remove jury trials. It seeks to allow for an accused to elect for a judge-only trial.
The Attorney General also pointed out that in the 2016-2017 law term opening, Chief Justice Ivor Archie advocated for the removal of trial by jury. The Chief Justice pointed out then that there was no constitutional right to trial by jury, but to a public and fair trial in front of an independent tribunal. Peter Christopher, C News.